Your Honor, at this time, the people would rest.
Oh, but you do that in front of this jury, though.
Oh, yeah. Oh,
Anything else, Mr. Neal?
yeah.
Your Honor, at this time, we make a motion for directed verdict. Don't believe based on the testimony presented here today, the people have established.
Testimony regard from the trooper today with regards to the traffic stop. We have heard also testimony from the Stanger along with as to the nature of this traffic of this transportation. That it was in fact for purposes of exchanging sex for drugs. We ask that the court deny the motion.
Taking the evidence in the light most favorable to the non-moving party who is a prosecutor, I do believe there's sufficient factual basis to allow this matter to go to the jury for ultimate disposition, and I will deny the relief requested in the motion for directed verdict. Anything else before we bring the jury in, gentlemen?
Nothing further, Your Honor.
Nothing further.
All right. And also, you both have had a chance to review the proposed jury instructions. Any objections, Mr. Babcock?
No objections from the people.
Mr. Neal?
No objection, Your Honor.
All right. Yeah. Please be seated. Mr. Babcock, you may call your next witness.
Your Honor, at this time, the people rest.
All right. And Mr. Neal, you had reserved opening statement. Do you wish to give one now?
Yes, Your Honor. Thank you.
Good afternoon again, ladies and gentlemen. Ladies and gentlemen, you're going to hear testimony in this particular matter outside of what you've already heard from Mr. White. You're going to hear from Mr. White how Mr. White and Mr. Stringer came into contact with one another. You're going to hear on the day of this particular incident what they were doing and where they were going. You're going to hear from Mr. White the intended purpose behind the two of them being together for that evening. Ladies and gentlemen, based on the testimony that will be presented on behalf of Mr. White, in conjunction with the testimony that has already been presented by the two previous witnesses, we're going to ask you to make a decision at the end of that testimony. At the end of that testimony, we're going to be asking you to make a decision and find Mr. White not guilty. Thank you.
Mr. Neal, you may call your witness.
Your Honor, at this time, we would call the Alto one.
Do you solemnly swear that the testimony you shall give in this matter will be the truth, the whole truth, and nothing but the truth?
No, Mr. White, have a seat.
You can proceed.
Thank you. Mr. White, good afternoon.
Good afternoon.
Mr. White, I want to take you back to the day of April the 26th or 27th of 2018. Do you recall that day?
Yes,
And were you in fact in a vehicle traveling from Penn County or Rhodes back here to Saginaw?
yes, but that was after the fact. We made 2 stops,
When you say we, who are you referring to?
Ms. Stinger and I,
And where did you come into contact with Ms. Stinger at?
on the night in question.
On the night of April the 26th or 27th?
Yes, at the time, I was a supervisor for the state of Michigan. I had just gotten off work, and we're not allowed to take our phones in there. So when I got to my car and turned my phone on, I had like 12 messages from Ms. Stinger. You know, she and I were friends. I used to date her friend. That's how she and I came into contact with each other. So I saw she had all these text messages and calls. So I called her up and said, hey, what's going on? You know, I was at work. I couldn't take my phone into work. And she asked me would I come pick her up and take her to her boyfriend's house. Now, keep in mind, she and I were friends and she lived
Okay,
with
let
me.
me stop you for a second. So you had a conversation with her, correct?
Correct.
This day. You called her back.
Yes, correct.
And during the course of that conversation with her, was it established that you would come and pick her up?
I was reluctant because I had to be back at work at 5 a.m. I had to get up at 3. I worked an hour away at least. But she kept asking because she really wants to see her boyfriend. And like I said, she was a friend. So I agreed to give her a ride to her boyfriend's house.
During the course of the conversation, this was a telephone conversation, correct?
Correct.
Did you ever have any conversations with her about giving her drugs?
No,
Did you have any conversations during that conversation with her about having sex with her?
no, because I had to be right at work. You know, I just wanted to take her where she was going and I was getting a pizza. That's when the cops pulled us over. I was on my way to the nearest Little Caesars and the cops pulled me over en route to Little Caesars. But no, she was going to be at her boyfriend's house and I was going to be home and off to work the next day.
So you did go, in fact, pick her up
Correct.
and you were taking her to her boyfriend's house?
Correct.
Where was her boyfriend's house?
Not too far from me. He lived on the west side of Saginaw. I lived in a Class A neighborhood, but I'm going to say his house was 5 minutes away probably.
Had you spent time with her before?
Yes.
She been to your house previously?
A lot of times.
Okay.
Mostly on her own.
Anytime that she's come to your house, did you ever give her drugs?
No, sir.
Had you engaged in a sexual relationship with her?
A couple of times, but we really were friends more so than anything.
You never gave her drugs or money to have sex though, did you?
Not at all. And she stated that in a police report that
Okay, let me
she was
stop you for a
attracted to
second.
me for my personality.
Now, on this particular day, did you have any drugs on this day?
No,
The day
I've
to
never.
stop?
No, I've never had any drugs.
And
I
it
don't
was-
smoke, drink, do drugs. 2 years ago, I was a vegetarian.
And you never had any intentions on giving her drugs in exchange for sex when you went to pick her up. Is that true?
Not at all. I actually I was a counselor too at the time, part-time. So I used to always give her good advice, like, hey, you were the star in high school playing baseball. Why don't you pursue that? She was like, well, I had bad grades. I said, well, you can go to a junior college and bring your grades up and transfer to a university. You know, she used to show me the videos of her talents in baseball. We were friends.
All right. And subsequently, there came a time where you did encounter the MSP that night, correct?
Correct.
And they didn't put you in a police car?
No, initially they pulled us over and they were talking to us. Neil, Michigan State Trooper Neil, and his partner, they were saying really harsh things. Not Officer Sidelet or Sonderegger, but
You had a contact that night with Officer Sidelet, correct?
correct.
Trooper Sidelet, correct?
Yes.
He was an issue officer that made contact with you.
Yes, he and
Yeah.
Sonderegger.
At some point in time, both you and Ms. Stinger got out of your vehicle, correct?
Correct.
And did you subsequently were taken down to the police station, is that correct?
Correct.
And prior to getting in, you were taken to the police station in the trooper's vehicle, correct?
Correct. They
And
just
prior
wanted to ask a
to-
couple of questions. I was never under arrest.
Prior to getting inside of the police cruiser, you were searched, weren't you?
Yes.
Was drugs found on you?
No.
Was drugs found on anyone?
No.
When you picked her up, you said you were taking her to her boyfriend's,
Correct.
and then you attempted to go pick up a pizza.
Correct, because he wasn't at home or he wasn't answering his phone. So I said, all right, well, I didn't eat all day. I just got off work. You want some pizza? You can wait at my house. You can wait at my home until he picks up the phone or he's home, and then I can take you over there. But en route to picking up the pizza, that's when the Michigan State Troopers pulled us over.
All right. No further questions, John.
Questions, Mr. Babcock?
Mr. White, you were obviously present in this courtroom when Ms. Stanger testified, correct?
Correct.
And you've heard Ms. Stanger testify that that the purpose of this trip was not to go to her boyfriend's, it was to go back to your place. You've heard that testimony, correct?
Correct. She's been established as inconsistent with her stories. She said multiple different things on numerous occasions.
So you're saying that she is making up the fact that she's an addict?
I haven't talked to Ms. Stinger in almost 2 years. I don't know what she's been up to lately.
Yeah. Are you?
But I know she dibbled and dabbled, drinking and stuff like that.
Yeah. Now, you know, you worked, you said for the state of Michigan back then.
That's correct.
And of course, if word got back to your supervisors that you were providing drugs to individuals, that would not go well with your employment. You would-
I
Correct.
never provided drugs.
I'll sustain the objection.
So you're saying you did have a sexual relationship with Ms. Stanger, at least some.
She and I were more so friends. She had a boyfriend, Alan. I've talked to him before. He's been in my home. But yeah, when people are around each other, sometimes they do develop feelings for each other. She stated she was attracted to.
And this person were you attracted to her?
More so as a friend. You know, she made attempts to become my significant other, but I just said, you know, you need to work on yourself, you know, don't seek love, you know, work on your purpose and love will find you.
So you're saying that she needed to work on herself. Is that what you're saying? You told her that you have to work on yourself?
Keep in mind, I was a part-time counselor. She came to me for advice. There was a time at 3 a.m. in the summer of 2019, her boyfriend, Alan, brought her to my home and she came in my door crying. I was like, what's wrong? She was like, well, you know, Alan is putting pressure on me to marry him. And then I got all these other guys doing this and that to put pressure on her to become a significant other. And I said, well, and she said, well, she called me D. She said, D, well, why aren't you like these other guys in Allen? I said, well, you know, I don't see you with my eyes. You know, I let my heart speak volumes for you as a friend. You know, a real friend is, or somebody that has your best interest in mind, they're not going to put pressure on you.
So you're saying that you would have her come over to your place so you could provide counseling for her? Is that what you were trying to
No,
do?
we were friends. She would come over without even calling me a lot of times.
But you
She
said
lived
earlier,
with me momentarily.
but sir, you said earlier you were a part-time counselor, and then you suggested, at least to me, at least, that that's part of the reason why you were having her come over so you could provide counseling. Is that what you're saying you were doing?
In addition to being her friend, I did give her advice sometimes as a counselor.
Is it your practice as a counselor to have sex with people you're counseling?
She wasn't one of my clients. She was a friend.
But who you were providing counseling services for, according to
I
your
wouldn't say I was
testimony?
providing services. She was a friend.
Uh-huh.
So the fact that she was a friend, friends look out for each other. Friends have each other's best interests in mind.
So you're saying she was a friend? Is that what you're saying now, sir?
She was a friend more so than anything.
And yet this friend you talked about, you heard her come in here today and talk about how on multiple occasions you would drive her to your place so you could exchange sex for drugs. You heard that testimony from your friend.
Former friend.
Oh, now she's your former friend.
Well, I said at the time we were friends. We're talking about 3 years ago. I haven't spoken to Miss Stinger in about 2 years or seen her.
Now, isn't it true that I think you testified earlier, there was other people that would come over to your place too and hang out? Is that true?
No, I never said that.
Were there other women that would come to your place?
Objection, Your Honor, relevance.
I'm,
I'll sustain the objection.
Yeah, you're right. I'll move on. And it's your testimony today that you never provided my client with any drugs. Is that what you're, not my client, Ms. Stenger. I'll rephrase. So it's your testimony today that you did not provide to Ms. Stenger any drugs at any given time.
in her police report, she stated that.
I'm
not a
asking
drug
what you
dealer.
said. I'm asking your
I've never
testimony, not what
provided
someone else
drugs,
said.
alcohol. I don't smoke, drink, do drugs. I've never had them in my home. My home was searched and my vehicle that night. They didn't find any drugs or alcohol or anything. As a matter of fact, I reported.
Sir,
that
there's no
cop to
question
the
on the table at the
FBI,
moment.
And he's
Sir.
being investigated.
Wait a minute, the format is question, answer, okay?
Sorry, Your Honor.
And you're saying that so you're saying you weren't aware of the fact that your friend had a drug addiction for heroin, and I think it was cocaine, back in 2018? Are you saying you didn't know that?
She didn't do it. She never brought that stuff around me. Remember, I didn't drink, smoke cigarettes or anything. I had joint custody of my minor child at the time. She was not allowed to do anything like that around.
Well, my question is this: did you know whether she had these addictions back in
Yeah, I
2018?
stated that earlier, that she dibbled and dabbled sometimes, to my knowledge, from what I've heard.
Didn't she outright tell you that she had these addictions?
They were not constant.
My question was very specific, sir. Did
Objection, Your Honor,
she
action answer.
ever tell you?
It wasn't asked and answered, overrule the objection.
Did she ever tell you that she had these addictions back in 2018?
She didn't say she was an addict. She said she dibbled and dabbled. I mean, maybe she was saying that to impress me because I didn't smoke, drink, and I was a vegetarian. I didn't do drugs. So she saw the type of aristocratic friends that I had. You know, all my friends were college graduates and had prestigious occupations and so on and so forth. So maybe she didn't want to tell me that because she wanted to make an impression on me.
Sir, I'm not asking you to speculate as to why, provide speculation. My question was very simple. And so your answer is she may have made some mention of it. Is that correct?
She stated she dibbled and dabbled sometimes.
In these drugs that we're talking about.
Drugs, alcohol, marijuana.
And your friend, as you put it, also testified. You sat here and listened to her testify about how you would take advantage of her addiction. You heard that testimony, correct?
That's not true. I try to steer her away from.
My
any
question
type
was
of
very
violence.
specific, sir.
I
Did you
said
hear
that's
her
not true.
testimony?
Yes, and I said that's not true, sir.
And does that anger you that she would come in here and make those statements about you?
The fact that we were friends at one time, it's very disappointing to hear her say that, yes.
Now, isn't it true? Did you also hear by Ms. Stenger also testify about the fact that you guys had told the state police that you were going to the casino that night?
I never told the state police that.
Were you present when that statement was being made?
They kind of separated us, so the things I recall, the state trooper saying, Trooper Neil and his partner, they were saying stuff like, how do you
I'm
afford
not
this car?
asking you what they said. I'm asking you whether or not that statement was, whether you were present when that statement was ever made while going to the casino.
You know, they separated us. I never stated that.
I
Now,
know,
she could have said that because they separated us for a moment. So she could have stated that, but I never told the cops that.
and you also heard, was here when the trooper testified as well, correct?
Yes, sir.
And how you drove past your own residence with the state police sitting there and kept going. You heard that testimony, correct?
Yes, sir.
Again, you would agree that that sure isn't consistent with going to check out and get a pizza. You would just drive by your own house, police there, wouldn't you?
Well, the police were not at my house directly. They were on the west side of the street and I lived on the east side.
So the fact that they were near your residence, you're saying it didn't cause you any concern whatsoever?
They were across the street on the west side. My home was on the east side of Graham. So I thought they were at a neighbor's house. Ideas would be like, wow, I wonder what's going on with my neighbors. They got all these cops in front of their house. They were never directly in front of my house or on my porch. They were across the street on the west side. I lived on the east side of Graham.
So what you're saying is had they been on your side of the street, that would have been a different story, is what you're saying.
If they had been at my house, I would have stopped because I would have wanted to know what was going on. I had done nothing wrong. I didn't go to jail that night. I wasn't given a ticket. I wasn't summoned to
Sir,
court, nor was I arrested.
sir, my question was very specific. One moment, Your Honor. I have nothing further to this witness, Your Honor.
Anything else, Mr. Neal?
Briefly, Your Honor, thank you.
Mr. White, you just testified that you initially seen the police. They were across the street from your home.
Correct.
Nothing, by them being across the street from your home, nothing in that gave you alarm that they were looking for you.
Correct. I thought they were at my neighbor's home. They were across the street.
And you indicated you were going to get a pizza.
Correct.
Is there a pizza place somewhere in close proximity to your home?
Yes, on Gratiot. That's about 2 minutes away from my house.
And that's where you were headed?
Correct.
No further questions.
If you look at the location of where I was pulled over, I was headed southeast in the direction of Gratiot. From Graham, I headed southeast in the direction of the Little Caesars on Gratiot.
No further questions, Your Honor.
Anything else, Mr. Babcock?
Nothing further, Your Honor.
I have a few questions, Mr. White.
Yes, sir.
You indicated that you got off work and you saw several text messages and phone calls from Miss Stinger. Is that correct?
Correct.
In those texts and phone calls, was the discussion that you would drive her to her boyfriend's home?
Yes.
And did you discuss bringing her back home after going to her boyfriend's home?
Well, no, she was gonna stay there at her boyfriend's house. I had to be at work at 5 a.m. for the state of Michigan. I had to get up at 3 a.m. That was the agreement. I was like, I can't take you back home because I gotta get up early. She was like, no, it's fine. I'm gonna stay at this house. I was like, okay, that's no problem.
Okay, and where was your work location when you came out and saw these text messages on your phone? Where were you located?
Where was my work
Yeah,
location?
where were you at that night? Where was your job?
The St. Louis Correctional Facility,
Where is that at?
in St. Louis, Michigan.
Okay. And then you went to her parents' house and picked her up?
Yes.
How far from your place of employment to her parents' house? Miles, how many would you
Oh.
say?
That's just outside of Penn County, so 30 miles, maybe.
30 miles from your place of employment to her parents' house?
Oh, no, no, I'm sorry. I misunderstood the question. From my place of employment, that would make it at least an hour probably.
So from St. Louis to where her parents live, you drove an hour to pick her up.
About that, yes.
Okay. And then from her parents' house to your house, how far a ride is that?
That's about 30 minutes.
About
from
30
Penn
minutes.
County to Saginaw.
Okay. And so let's see. So your testimony is you drove 60 minutes to pick her up from her parents' house, right? You drove 30 minutes back to your house, right?
Right.
And you did that just why?
I was reluctant.
No, no.
We argued about it. I was like, oh my goodness,
No, no.
you can't get.
My question is, what was your motivation for doing so? Why would you drive an hour and a half just to pick up and take her to your boyfriend's house?
She was a friend and she was, I didn't want her to get in trouble and she didn't have license and she was gonna drive her parents' car. I think her license was suspended. But, so
So you
that was the
just
reason.
felt it was okay. You didn't mind driving 60 minutes to pick her up, 30 minutes back to her boyfriend's just because you didn't want her to get in trouble.
Well, she was a friend. I protested. We argued.
No, but you understand my question is you drove an hour and a half, basically, just because you didn't want her to get in trouble.
She was a friend. I was doing her a favor too.
And what time did you get off work?
7 p.m.
And you had to be at work at 5 a.m. the next
5
day?
a.m. But yeah, usually when that was my schedule, 5 a.m. I wouldn't go to bed till like midnight anyways.
Okay.
But we arrived at my home probably in the 2100 hour, 9 p.m., 9-ish.
Okay. Any other questions, Mr. Babcock?
No further questions, Your Honor.
Mr. Neal,
No question, John.
you may step down. Any other witnesses, Mr. Neal?
No further witnesses, Your Honor.
So you rest.
Yes.
Any rebuttal, Mr. Babcock?
Nothing for the people, Your Honor.
We prepared to go into closing arguments, gentlemen?
Yes.
Yes, Your Honor.
All right. You can move the podium if you'd like to also, Mr. Babcock.
I'll just stay right where I'm at. Ladies and gentlemen of the jury, as I said, we've tried to be very quick and get this case presented to you. Let's talk about the evidence here. You sat and heard the testimony from the trooper about the nature of the traffic stop. You heard the testimony from Ms. Stanger about the nature of the trip that was taken that day. In fact, it wasn't the first time. There was a number of times where this had happened, where he had picked her up and taken her back to his place to
Objection,
exchange.
Your Honor, he's arguing facts, not in that.
Mr. Neal, this is a closing argument. The jury will be instructed that whatever the lawyers say is not evidence, and they're allowed to do what they want with what the lawyers say. Overrule the objection. Proceed.
Anyway, she had testified about how this was the way they dealt with things. He'd take her back to his place. They'd exchange sex for drugs. And you could see, I would respectfully submit, how difficult this was. And I would ask that you consider in the testimony today, the credibility of the witnesses, the way they talked, the way they explained themselves. And when you compare that with the testimony of Mr. White, who would like everyone to believe that on the day in question, he made an hour-and-a-half drive from work, from St. Louis to Pinconning, back to Saginaw, just because he was a friend. And even though he had to be at work, as he said, bright and early the next morning. That's the explanation that the defendant would like you to believe. We believe beyond a reasonable doubt, that what really was happening here was exactly as Ms. Stanger testified to. That this was a transaction where she was being transported with the express purpose and intent by Mr. White to go back to his place and exchange sex for drugs, by very definition, that of prostitution. We'd ask that you consider the evidence and find the defendant in this case guilty as charged.
Closing remarks, Mr. Neal.
Thank you. Commissioner move about, Your Honor.
You may.
Ladies and gentlemen, you've heard the testimony today. You've heard the testimony of Cooper. You've heard the testimony of Stringer. And you've heard the testimony of Stewart. At the beginning of this trial, we talked and had in depth a very specific conversation. Conversation that the prosecutor must prove this case beyond a reasonable doubt. You heard the testimony of everybody that testified. You heard the trooper tell you him and other officers were at Mr. White's house to conduct a search. You heard Mr. White tell you that at the time that he observed the troopers, they were at the house across the street, not his. You then heard the trooper tell you they saw Mr. White drive by. What kind of car was it? You don't know. What color car was it? We don't know. The trooper could not recall. The trooper then subsequently had contact and made a traffic stop on Mr. White with a stinger. At that time, he removed both of those occupants from the vehicle in which they were traveling. He conducted a search on both individuals. That was a search on his person, search on the Stringer's person, and there was a search in his house. They didn't find drugs on him. They didn't find drugs on her. And they did not find drugs at his house. But the prosecutor wants you to believe that they were going to exchange drugs for sex. Exchange something that nobody had. One, Mr. White didn't have drugs on his person. Mr. White didn't have drugs at his house. And he drove past his house before getting stopped by police. Now you heard the testimony of the stinger. At no time on the night of this stop, April of 2018, the trooper tell you she was going to go have exchange sex for drugs. At no time in April of 2018 did she tell you she was about to go and exchange sex for drugs. In fact, she told you a whole year and a half later, October 30th of 2019, while she was in jail, was the next time she had contact with MSP. She told you the statement she made at no time in that second contact. did she tell them she was going to have sex in exchange for drugs from Mr. White? She told you. You heard me ask. Didn't you tell the officers you were going to the casino? A year and a half later, she told the officers they were going to the casino. No time in that. This trooper or anybody. You heard her tell you again. She was contacted again, a third time, in November of 2019. By the trooper. This time alone. Not with the other trooper that he made contact with. Second time.
I didn't hear you.
She didn't make that statement.
Thank you.
Third contact. While she's in jail. And now she says, we were going to exchange sex. A year and a half later, 3 contacts later. But you heard her say, she lied. First night, she lied. Second time they had contact with her in jail in October. I submit to you, she's lying here today. Ladies and gentlemen, you heard the testimony of Mr. White. Mr. White told you he got off of work about 7, picked her up to take her to his work. And he saw the police and was going to go and pick up pizza. Now, again, the prosecution has the burden of proof, not Mr. White. Mr. White told you he was searched that night. No drugs were found, again, on his person or at his house. Mr. White told you he was not arrested or ticketed April 2018. It wasn't until a year and a half later, November 2019, we're sitting here today. Ladies and gentlemen, the evidence speaks for itself. Prosecution has the burden of proof. This is a he said, she said. I'm asking you to find my client not guilty.
Rebuttal remarks, Mr. Babcock.
Yes, Your Honor. Just briefly. We've heard an interesting version of facts presented today. But I think if you don't remember this thing, she did testify. Now, notwithstanding the fact that the defense counsel kept talking about these other meetings, she testified that initially she brought up, when they first pulled her over, she brought up the, this is on April 27th, she brought up the casino. But then she went on and explained herself. And she said, well, as I'm sitting there, it started coming out. And that's when she explained that she told the trooper here what really was going on. So this was not something that was fabricated or disclosed years later, as defense counsel would like you to believe. On the day in question, Ms. Stenger testified. She disclosed these facts to the trooper. Now, at the very beginning of this case, the trial, I talked to you about what you're going to be asked to do here. In fact, you're going to be given a jury verdict form. And the question is, that you're going to be is not guilty is one option. Guilty of transporting a female for purpose of prostitution is the second option. Now, as I indicated at the very beginning, this is a very narrow question. The question isn't whether they were successful in exchanging sex or drugs. They never got that far. The question is, leading up to this traffic stop, why was she in that vehicle? Why was she there? Was it to go see her boyfriend? He drove allegedly an hour and a half, just drive her to her boyfriend in Saginaw? Or is it more believable, he had a reasonable doubt, that he was driving her back to his residence, so and that's what he conveyed to her, and that's what was going on. Is that more plausible? Is that beyond a reasonable doubt? I say it is. I say it is, ladies and gentlemen. Beyond a reasonable doubt, we have met our burden. And we'd ask that you again find the defendant in this case guilty as charged.
Members of the jury, the evidence and argument in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember, you've taken an oath to return a true and just verdict based on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that you may have been unintentionally influenced by stereotypes. You must reach your own conclusion about this case individually, but you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of this case are. This is your job and no one else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. When you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If the lawyer says something different about the law, follow what I say. At various times, I've already given you some instructions about the law. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way to decide the case. A person accused of a crime is presumed to be innocent. This means you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find the prosecutor is not proving every element beyond a reasonable doubt, you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a carefully considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some of the things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to witnesses and my questions to the witnesses are not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It's my duty to see that the trial is conducted according to the law and to tell you the law that applies to this case. However, when I make a comment or give an instruction, I'm not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decision only on the evidence that I let in and nothing else. Your decision should be based on all the evidence regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence. We should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think the testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have based and not be influenced by a witness's disability, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age and maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that the witness deliberately lied about something that is important how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You heard evidence that before the trial, a witness or witness made a statement or statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement made before the trial only to help you decide how believable the witness's testimony was when testifying here in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statement when determining the facts of this case. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So for example, if we see a person coming from outside wearing a raincoat covered with small drops of water, there'll be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself or a combination of circumstantial evidence and direct evidence can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, how he did it, or by any other facts and circumstances and evidence. You've heard testimony from a witness who is a police officer. That testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. The defendant is charged with transporting a female for the purpose of prostitution. To prove this charge, the prosecutor must prove both of the following elements beyond a reasonable doubt. First, if the defendant transported, caused to be transported, or aided or assisted in obtaining transportation into, through, or across this state for a female for the purpose of prostitution. Second, that the defendant did this knowingly and intentionally. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 26, 2018, or April 27, 2018, within Saginaw County. When you go to the jury room, you'll be provided with a written copy of my final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it's necessary that each of you agrees on that verdict. In the jury room, you're to discuss the case among yourselves, but ultimately, each of you have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It's your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and the reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your own honest opinion about the case just because other jurors disagree with you, or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations, or questions about the instructions that arise during deliberations, you may submit them in writing in a sealed envelope to my law clerk. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by law. If you want to communicate with me while you're in the jury room, please have your foreperson write a note and give it to my law clerk. It's not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and full instructions. When you go to the jury room, you'll be given a written copy of the instructions you've just heard. As you discuss the case, you should think about all my instructions together as the law you are to follow. You may return a verdict of guilty of the alleged crime or not guilty. I've also prepared a verdict form for you listing the possible verdicts. It reads, count 1, transferring a female for purposes of prostitution. Your possible verdicts are not guilty or guilty of transferring a female for purposes of prostitution. Once you've reached the verdict, the foreperson will sign and date the verdict form. I'd like to see counsel at the bench, please. Okay, Ms. Rhodes and Ms. Pease, even though you've been excused at this time, I still would ask you not to discuss the case with anyone else because as alternates, should the need arise, you'll be called back to continue deliberations, all right? You may now administer the oath to the jurors, please. And Ms. Pease and Ms. Rhodes, you can all stand as well. Okay.
You and each of you do solemnly swear that you will well and truly try the issues joined in the cause now be pending and unless discharged by the court, a true verdict rendered, and that you will do so solely on the evidence introduced and in accordance with the instructions of the court, so help you God.
All right, you can now administer the oath to the law clerk.
You solemnly swear that you will, to your utmost ability, teach the person sworn as jurors in this trial, in private and convenient place, that you will not suffer any communication related to them or or otherwise, you will not communicate with them yourself or otherwise, except by order of the court, to ask them if they have agreed upon their verdict, until they shall be discharged. If you will not, before they render the verdict, communicate to anyone the state of their deliberation or the verdict they have agreed upon, so help you God.
All right, ladies and gentlemen, at this time, we may go to my law clerk and begin deliberations.
All rise for the jury, please.
You can go as well.
Records should reflect the jury is not present at this time. Anything for the record, Mr. Babcock?
Nothing for the people.
Mr. Neal?
Nothing, Your Honor. Thank you.
All right, I would ask you both to remain nearby. It's about 3:30. If you are going to leave the facility, give my staff a telephone number. You can be reached at and return as soon as possible. We'll stand in recess right now.
Thank you, Your Honor.